Okay, today for our class, this is a class, this is not of live persons. We're going over and dissecting the actual purchase and sale agreement and what that looks like. So page 1 is where we fill things out, and the rest of the pages 2 through 6 describe what we have filled out. So when we look at paragraph A, which is I think one of the most important, I'm going to close doors. Hold on, it's a little loud in here. Okay. When we describe purchase price means that the buyer shall pay to the seller the purchase price, including earnest money, so it's not above and beyond, in cash at closing unless otherwise specified. An example would be financing. Have to sell my home first. Money's coming out of the home I'm selling, whether I've put it on the market yet or not, and whether I have an offer on it yet or not. So buyer represents that they have sufficient funds to close, that they have to bring, let's say, $100,000 to the closing table. They are buying a home that is 600,000, so they're getting a loan for 500,000, and all of their closing costs for a total of 100,000 minus $10,000 that they have in earnest money. So they have to write a check to come to closing for $90,000. So they represent they have this money. They have money to pay for the earnest money. They have money to pay for any closing costs and their down payment based on them signing this agreement, and that cannot change. So they can't go off and buy furniture, cars, spend money in other places, hoping that, oh, I'll get another paycheck to make it up. They need to make sure that they keep these funds safe and maybe in a different account so that they don't spend it. Because if they do, and they're representing they have sufficient funds to close, and all of a sudden the lender says, sorry, they don't have enough money to close, I'm not going to do the financing, buyer will be in default and buyer will lose their earnest money. They're not relying on any other contingent sources of funds, including loans, the sale of other properties, gifts, retirements, or future earnings, except to the extent that they have disclosed it in this agreement. The party shall use caution when wiring funds, which everybody should sign their wiring, fraud, potential disclosure that we give them in all of our packets. So when you sit down with your buyer at your consultation, 100% you're asking them, where is your money coming from? If they talk about stocks, bonds, 401ks, gifts, we might need some more paperwork in order for them to be able to legally close this transaction and not lose their earnest money. Earnest money. Buyer shall deliver the earnest money by the delivery date listed in specific term 7. When I talk about specific terms, the specific terms are the numbers that are on the left-hand sides of the spots we fill in. 2 days after mutual acceptance unless otherwise specified. In page 1, you can disclose maybe it's 3 days, 4 days, 5 days after mutual acceptance. If this is not filled in, the default is 2 days. To the party holding the earnest money. We cannot hold the earnest money. We don't have a trust fund account, so it has to go to escrow. So escrow will be the one that is holding the funds. Upon termination of this agreement, a party or the closing agent, which will be the closing agent, may deliver a form authorizing the release of earnest money to the other party or parties. That form is known as Form 50. If the buyer is legally terminating using a termination notice, which is the 90 series or the 35R, and a Form 50, then that is instructions to the closing agent to release the money to whichever party. In this case, buyer's doing it legally, buyer should get the earnest money back, but all parties will need to sign Form 50 or escrow will not release the funds. The closing agent shall deliver a notice of, okay, so let me go back a little bit. The party shall execute such a form, Form 50, and deliver the same to the closing agent. If either party fails to execute the release, a party may make a written demand to the closing agent. So if I send off written demand on behalf of the buyer, and the seller never signs it, escrow may, which I've not known them to do, but they may deliver notice of the demand to the other party within 15 days. If the other party does not object to the demand within 20 days of the closing agent's notice, closing agent shall disperse the earnest money to the parties making the demand within 10 days of the expiration of the first 20-day period. If closing agent timely receives an objection or an inconsistent demand from the other party, the closing agent shall commence on what we call interpleading actions within 60 days. That means that buyer and seller are fighting over the earnest money, and now it has to go to a court proceeding that we cannot be involved in. I recommend that those parties both get attorneys They will be subjective to taking a $750 amount out of the earnest money amount that's currently at escrow to start the process. And whoever loses will have to pay the opposing attorney fees as well and lose the earnest money. So getting into an interpleading situation is not the best way to go, if at all. I've only seen a few in my lifetime here. But and again, I never know what the turnout's going to be, but I've watched people send it over to interpleading, and whatever the outcome is, nobody shares. Included items shall be identified in specific term 5, and 5 was where we disclose any of the items such as appliances or generators, satellite dishes, those types of items, but it shall also include if the corresponding box is checked, located in or on the property are included in the sale, built-in appliances, wall-to-wall carpeting, curtains. If the curtains are hanging on a curtain rod, even though the curtain rod is really the only thing that is nailed into the wall, the curtains also stay. Drapes, other window treatments, door screens, awnings, storm doors, windows, installed television antennas, ventilating, air conditioning, heating fixtures. So all of these items, shrubs. So if you've got this giant attached mirror and let's say a 2-story staircase and it's attached to the wall, it's not hanging by, it's probably not hanging, it's probably really attached because of the weight that it bears, that will have to stay with the property. So if the seller wants something to go, like I had an example of the wine fridge in a butler's pantry, yes, it's plugged in, yes, it's under the counter, looks like it's built in, technically it's not. For pure safety, I make sure that I exclude those items that the seller wants to take on a Form 22D, optional clause addendum, page 1, excluded items, maybe it's page 2. Excluded items to make sure that those items are there. If they want to take prize rose bushes that they've been growing for years, tag them with a colored ribbon in optional clause addendum, Form 22D, excluded items, any bush, shrub, flower tagged with a pink ribbon shall go with the seller upon closing. And then that avenue is already written in. You just have to put what is being excluded. Now, condition of title. This has nothing to do with the actual title contingency. This is where it actually says that the buyer can't close if it doesn't have marketable title. So unless otherwise specified, title of the property shall be marketable at closing. The following shall not cause the title to be unmarketable. Any rights, reservations, conditions, restrictions, covenants of record already there. So if those items are already posted, it cannot cause unmarketable title. And easements, encroachments not materially affecting the value of or unduly referring the buyer's reasonable use of the property. So this is where it says that the seller will transfer it based on a statutory warranty deed. If you've got a bargain sale deed or a sheriff's deed, you're going to have to add language for the fact that this particular paragraph will not work. And a buyer could have an out if you don't rectify that somewhere along the line in a purchase and sale agreement. Do not cross out here and write things. Use another avenue. If you're countering because you're adding this language in, you're going to want to use a counter offer form 36 to add that in. Title insurance. There's 3 policies there. That's why I use these 3 fingers. There's standard, homeowners Alta, and extended. This paragraph, paragraph E, says that they're getting the middle of the road. The seller authorizes the buyer's lender or the closing agent at the seller's expense to apply for the then current Alta form of homeowner's policy of title insurance for anywhere from a 1 to a 4-plex residence from the title company. If the seller previously received a commitment from a title insurance company, the buyer declines to use them, the buyer may have to pay for the cancellation of that currently open preliminary title. Otherwise, the parties shall apply for the title insurance and shall pay any title cancellation fees in the event such a fee is assessed. If the title insurance company selected by all parties will not issue a homeowner's policy, then the buyer and the seller agree that they will take the next available, whatever the current Alta homeowner's policy is. The buyer is going to pay for the lender's policy, so there'd be 2 policies written, and the seller is going to pay for the buyer's policy. And that's how title insurance paragraph E works. Closing and possession. The sale shall be closed by the closing agent on the closing date. If the closing date falls on a Saturday, Sunday, or legal holiday, it shall close the next business day that they're open. Escrow will not actually do that. If you need to move the closing date because you accidentally put it on a weekend or a holiday, then you need to use Form 22Y to change or modify that closing date. Closing means the date on which all documents are recorded, so you get recording numbers, and the sale proceeds, the money is available to the seller. Not that they have it in hand, but it is available to them, whether it's gonna be wired later or they're gonna drive by and pick up a check. Seller shall deliver the keys, any remotes, access codes to the buyer on the closing date or the possession date, whichever occurs first. However, the buyer will not be entitled to enter the property until 9 p.m. of the closing date. So if closing happened at 2 p.m. today, buyer can get the keys, but the buyer can't access until 9 p.m. Seller shall maintain the property in its present condition, normal wear and tear, keep the lawn mowed, keep it green. Don't put any large dents in things. Be careful moving furniture. Nail holes are very standard wear and tear. Seller shall either repair or replace any system that may become inoperable, including appliances, heating, plumbing, electrical, and such, or malfunctions prior to closing, with a system or appliance of at least equal quality. Now that means that if let's say the dishwasher breaks, seller has to replace it if it was working at mutual acceptance. Then the seller does have to replace it with like kind. So they can't go and put a white or a black or a stainless steel in if the actual dishwasher is of a different color. So find as best like kind model. It doesn't have to be brand new, but it does have to be working. So the seller does have to replace that. The buyer reserves the right to walk through, oops, dang it, to walk through the property 5 days before closing. If your closing is on a Friday, this is the only way that we count wrong. When we have 5 days or more and we land on a weekend or holiday, we move forward. If we're doing a walkthrough where you're counting backwards from a closing date, then we move back. So if Friday is our closing date, so that's 1, 2, 3, 4, actually it should be the day before. So if Friday it is, so then Thursday, Wednesday, Tuesday, Monday, Sunday, we go back to Monday. So it comes back the opposite direction. That's the only way we count backwards. Closing to verify that the sellers maintain the property and the systems or appliances as described in this paragraph. Sellers shall not enter into or modify any leases or rental agreements, any service agreements or other agreements affecting the property, which may go beyond the terms of the closing date without buyer's consent, which shall not be unreasonable. If the possession transfer is at the time other than closing, buyers moving in early, sellers staying after closing, then we agree to insert new agreement 65A for buyer moving in early, seller moving out late, 65B, 65. They're both very dangerous to do. I recommend that they seek legal counsel if one party is going to agree to the other. I've seen situations where a buyer says, I want to just move into the garage. Can I do that 5 days prior to closing? Seller's like, no problem. Buyer never closes. So then what happens to all of the property? It now becomes technically the property of the seller. So it's very dangerous in any ways. I've also seen it where the buyer has agreed to a seller to have possession after closing up to 5 days, 2 weeks, 2 months, and then the seller never moves out. Now we have an issue with landlord-tenant law. So again, they're very dangerous agreements to put into place. Make sure that the insurance companies know who is the owner and who has possession, because there will need to be renter's insurance. There'll be property insurance to pay on who owns the property at the time of closing. It also says that the seller must have both a carbon monoxide detector in the property as well as smoke detector. So if you are a listing agent walking through the house, make sure that both of those items are there so that you don't get flagged by the lender after the inspection is in. Of course, an inspector will call it out, but at the same time, making sure that it's done causes less red flags. The buyer and the seller agree that if either party intends for the transaction to be part of a 1031 exchange, so they're either buying or selling a property to move from a rental property to another rental property for taxation purposes, it is agreed that the buyer and the seller will allow the other person to do it. The other person who is doing it needs to make sure that all of the costs are incurred by them. I recommend hiring a 1031 exchange company so that they do it properly. There's one that I recommend all the time out of California that I've never personally used because I've not done a 1031 exchange, but I do recommend them on a regular basis because I think it's important for a buyer or the seller to understand what are their timelines, how many properties do they need to identify in order to move forward. Closing costs, prorations, charges, and assessments. Seller and buyer agree to pay 1/2 of the escrow fee unless required by FHA or VA regulations. Taxes for the current year will be prorated. Rent, if there is rent currently happening, interest, lienable homeowners association dues. If I've already paid my $600 for the year and they'll prorate it throughout the whole year, they'll back out what I've already paid and they'll give me a credit from the buyer to pay for their portion. Buyer shall pay their loan costs, including credit report, appraisal, lender, title insurance, unless otherwise agreed in the agreement. If any payments are delinquent or encumbrance, which will remain after closing, the closing agent is instructed to pay such delinquencies at closing from monies due or to be paid by by seller. Buyer shall pay for any remaining fuel in an oil tank, a propane tank. Seller agrees to obtain written information, get it to escrow. Escrow will verify. Escrow will hold back or will charge the buyer to pay back the seller for any fuel that's left in a tank. Seller shall pay all utility and internet charges, including unpaid bills unless waived by specific term 12, which is the 22K. Seller and buyer request the service of the closing agent to disperse funds necessary. So 22K, which I do recommend in all offers, tells the escrow company who the lienable utility companies are. They will withhold money from the seller. They'll pay off those bills. Any money left over goes back to the seller, but that way the buyer doesn't come into a home encumbered by lienable utilities, which is not necessarily protected by the title report or the title company. The buyer is advised to verify the existence and amount of any local improvement district capacity or impact charges or other assessments that might be charged after closing, but levied today. So if you're going into a home that's maybe 10 years old, there's a high likelihood they have a sewer capacity charge. Sewer capacity charges run about 20 years. Is it 15? It's 15 years, about $20,000, $20,000 to $30,000 in a 15-year span. So there's 5 years left to pay this off. Is the seller going to pay it off with proceeds, or is the buyer going to assume the charges and start paying it off based on how the seller was currently paying? Always best to check with escrow if you do think there might be a sewer capacity charge or any other special charges based on a condominium, so that we make sure that if the buyer can't assume the charges, that the seller will pay them off. I have had many people get stuck with this, not knowing what it really means. Listing broker, buyer broker are authorized to report this agreement to the MLS. They will publish it for all of the members, for other financial institutions, for appraisers, or anyone else related to the sale. Buyer and seller expressly authorize the closing agent, appraiser, insurance companies, and other related to the sale to furnish the listing broker, buyer broker on request any and all information and copies of documents concerning the sale. It is very important we get that information properly into the MLS because we do use those for comparable reasons. Appraisers use them for comparable reasons. FIRPTA is where a seller may or may not be a foreign citizen for taxation purposes. The seller warrants based on using a Form 22E or something equivalent to disclose their residency based on income tax. If they are a non-resident alien in the state of Washington selling a property, they are subject to paying an income tax above and beyond excise tax, making sure that it is being paid by the seller. We confirm that escrow has a copy of 22E by doing two things. One, it's in supplements. We forward it to escrow to disclose it, whether they are or are not a foreign person. Two, we verify, it says here 10 days from mutual acceptance is the amount of time the seller has to furnish it to escrow. If they have not, then buyer can terminate the agreement 3 days thereafter, because if we don't know that they're a foreign person, buyer closes the transaction, buyer's on the hook to paying that income tax. So it's very important. That's one of our timelines that we verify when we're getting through the transaction. Notices and delivery of documents. Any notice related to this agreement, including revocations of offers or counteroffers, must be in writing. Notices to seller must be signed by at least one buyer, so a notice to a seller. and shall be deemed delivered only when the notice is received by the seller or their listing broker or the licensed firm or all three. Notices to the buyer must be signed by at least one seller and shall be deemed delivered once the buyer receives it or the buyer broker and the buyer firm receive it. Documents related to this agreement must such as an MLS Form 17, information on lead-based paint hazards, public offering statements, resale certificates, other documents shall be delivered pursuant to this paragraph. Buyer and seller must keep buyer, broker, and listing broker advised of their whereabouts. If they start to disappear during the middle of the transaction, we can't find them, that could cause harm to the other party. So if you know that your client's going on a vacation during the transaction, make sure that you're always able to reach them. If they're going on a cruise, there will be days where you will not be able to reach them, and that could be a problem. Either email transmission, fax transmission are legal sent documents. We're required by this paragraph to deliver it to the other side. So if I'm the listing broker, I'm going to send it to the buyer broker firm that are going to be named on page 1. And those emails will be down here at the bottom on both sides. I just recommend that you take all 4 emails, which is include your own. You're going to take yours, the listing broker, the listing firm, and send it over to them and vice versa. That way that when I receive an actual email, I just forward it over, or excuse me, I put it back into a label in my Gmail so that when I have to go capture emails, I can capture them quickly. I have a story about that when it was, gosh, I think it was the Everett office was the listing firm. Buyer sent over an offer, seller countered. In the meantime, while they're waiting for the counter to be signed, a better offer came in from buyer number 2, which they accepted, and they withdrew their counter offer from buyer 1. Buyer 1 said, whoa, I sent you mutual acceptance 2 hours ago. Listing agent says, I don't have it. Looked at the listing firm had it, but it has to be delivered to both parties unless I send an email to you saying, I have received it, thank you. If you don't get that from me and you have no idea if I received it, well, we went back and looked through who she sent them to. She sent them to the listing agent's Authentisign email, which is not her email. Authentisign has its own special system that when you email it, it goes into documents, but it doesn't go to the email that is required based on the first page of the purchase and sale agreement. So make sure that those are the emails that you know and use only when doing a transaction. Computation of time, unless otherwise agreed, any period is measured in days, not hours, not dates, unless otherwise specified, days. So 5 days or less are business days only. 6 days or more are calendar days, but cannot end on weekends or holidays. So if your 5th day is a Saturday, it moves over to Monday. If your 6th day is a weekend or holiday, it moves over to the next business day. And whatever that expiration date is, that time period shall end at 9 p.m. Possession is the only one where it is specified that it could be a Saturday, Sunday, or legal holiday to take possession. It does say that if your closing date ends on a holiday or a weekend, that the escrow will move it to the next day. Again, that does not occur. They will want you to use a Form 22Y to modify your closing date. If the parties agree upon and attach a legal description after the agreement is signed by the offeree and delivered to the offeror, then for the purposes of computing time, mutual acceptance shall be deemed on the day of the delivery of the acceptance offer, even though the legal description was missing at the time. Once it's delivered, it is now a non-voidable contract. So make sure, though, that you're always sending it if you have it in supplements. This agreement in its entirety between the parties supersedes any other underlining or representations. No modifications to this agreement shall be effective unless signed in writing and signed by buyer seller. Parties acknowledge that a signature electronic form is legal and binding, just like a actual handwritten. There will be some banks or some situations where they say that you are required to use an ink signature. That doesn't mean you can't transfer it after ink signed via email, but it has to be signed in ink, scanned in, and then emailed. Buyer may not assign this contract or any of the rights to the contract to another party without seller's written consent. Buyer has a choice that if they fail to close without legal excuse, that they are going to either forfeit their earnest money or they check the box that the seller can keep the earnest money and sue them, which is seller's election of remedy, which is not a great place to be in. Buyer friendly is forfeiture of earnest money. Buyers and sellers are advised to seek counsel at any given time or a public or a CPA so that they understand anything that may be foreign to them in this document or that you're not able to help them understand. If the offer is not accepted, then if the buyer or seller institutes suit against the other concerning this agreement, the party holding the earnest money commences interpleader, the prevailing party is entitled to reasonable attorney fees and expenses. So if it does go all the way to interpleading, whoever wins, they get their attorney fees paid by the losing party. At the top right-hand corner, we can actually put an offer expiration date. So the seller either has to accept by this date or counter. So the offer must be accepted by 9 p.m. on the offer expiration date, unless I withdraw it sooner as the party delivering. It will not be effective until a signed copy is received by the other party, by the other party's broker or at the licensed office. If this offer is not so accepted, it shall lapse and any money that may be deposited will be refundable. Any changes in the terms presented in this offer or counteroffer other than the insertion or the changing of the seller's name and seller's warranty of citizenship. So if the name is wrong, if you insert the name, maybe it had undisclosed, you insert the name, or you check the box for FIRPTA, that does not constitute a counteroffer. If a party making a counteroffer, then the other party shall have until 9 p.m. on the counteroffer expiration date to accept that counteroffer unless sooner withdrawn. Acceptance shall not be effective until a signed copy is received by the other party and brokerage. If there's no expiration date at the top, and that expiration date at the top is simply when the offer expires, that is not the counteroffer date. If the seller counters, then it becomes a 2-day window for the other party to accept or keep countering unless sooner withdrawn. So if there's no expiration date for offer counteroffer, the offer counteroffer expires 2 days after the offer counteroffer is delivered by the party making the offer counteroffer unless withdrawn. Buyer broker firm, buyer broker executive broker, buyer broker managing broker, and buyer broker managing broker represent the same party that the buyer broker represents. Same with the listing side. You either can represent one party, both parties, but you can never represent neither party. In the state of Washington, it states that if you have a listing agreement, you represent the seller. If you don't have a listing agreement and you're in a transaction with a buyer, you automatically represent the buyer. That's how agency law works. The seller and buyer shall pay compensation in accordance with any listing or compensation agreement to which they are party. The listing brokerage firm compensation shall be paid as specified by the listing agreement. The compensation offered by the seller to the buyer broker firm, if any, is set forth in specific term 17A. That's where the seller is saying, I will pay the buyer broker X. Now, buyer broker, in order to accept that money, you have to disclose on 17B. If 17B is left blank, you will not be able to accept any payment. So make sure that 17B is filled in. 17A and 17B can be different numbers, but 17B has to be the same number or less that is currently on your buyer broker service agreement form 41. If 17A is higher, 17B is lower, the buyer gets the difference paid as a credit from the seller. Anytime you have questions on 17A and B, please call me immediately. I just had a text message this morning where another buyer broker forgot to fill in 17B and is not going to get paid. There are ways out of it if you've got some contingencies potentially, but call me first before you get in that scenario. If you're writing an offer, please feel free to send it to me and I can tell you if anything is missing. If 22J was not delivered, which is the lead-based paint addendum, if it wasn't in supplements and you didn't have it in your offer, seller didn't provide it ahead of time, they sent it to you 1 day after mutual acceptance, your buyer now has 3 days to decide if they want to stay in the transaction or exit, kind of like Form 17. So if 22J is not part of the purchase sale agreement and it comes 5 days later, buyer again has 3 days after receipt to decide what they want to do, if they want to stay in or get out. So making sure as listing brokers, we have that in the offer to begin with. This is only if it is not received prior to mutual acceptance. Verification of information is a time period. The default is 10 days. If not filled in, you can either waive it, put how long the buyer has. If it's blank, it's still checked. That buyer has 10 days to verify any information the seller has given them. This is not a look and walk clause. This is a time period where the buyer can verify square footage information, lot information, anything that was given by the seller, they can verify to be true. If it's not true, buyer can terminate the transaction. Buyer and seller agree that we are not responsible for any of the information that either party is receiving. This is the disclosure for us to kind of CYA, and hopefully this will protect us. And finally, fair housing. Anytime one of your clients wants to have conversations that might breach fair housing laws, realize that we could be held liable if found out that we engaged in conversations that was not appropriate. We could be held liable at a federal level with either fees, jail time, or both. So making sure that anytime your seller or buyer is going to start talking in a negative way about fair housing issues or a person, that you shut it down immediately. So there is the boilerplate breakdown of the purchase sale agreement. Are there any questions? Well, I appreciate the two of you joining me today. I wish there was more. Tanner, do you have any questions?
Yeah, I was just gonna have a quick question on, and it doesn't apply directly to this because let's say it's a condo, special assessment,
Yes.
and if you were on the listing side, and let's say they had the assessment left, without an extra form, the seller would be on the hook for that assessment, or it would be the new buyer that's on.
So on both the condominium and the residential purchase and sale agreement, specific term 13, and it might be a different number on the condo, but one of these has to be checked. Assumed by buyer, prepaid in full by seller. Now, I don't believe the boilerplate, let's see if it dive in here a little closer. Let's see here. Buyer shall pay the remaining fuel tank. Okay, we talked about that. Sellers shall pay utilities. We talked about that. Let's come down here. Buyers advised to verify existing. Seller will pay such charges that are or become due on or before closing. Charges levied before closing but becoming due after closing shall be paid as agreed in specific term 13. So there is no course of action that it says who's going to pay it if a box is not checked.
Gotcha.
So that would be a something that would be a weird situation to be in, because both buyers and sellers would have to agree if it was left unchecked.
Right.
Janina, I have a question
Yes.
about title insurance.
Yes.
I'm confused. What is that?
Well, title insurance we have on all properties. If you have a loan, we have to have title insurance to ensure the legal description. So title insurance protects a client from having non-marketable title. So let's say they moved in, it was marketable title, buyer moved in, they found out that the fence line, the neighboring fence line was on the wrong side of the property. Title insurance would cover the cost of having it moved to the proper location.
And you said there are 3 types?
Yes, there's standard, there's homeowners, and there's extended. Standard and homeowner, you can either downgrade or upgrade by using Form 22D and checking one of those boxes. Otherwise, the buyer automatically gets the middle of the road.
And the seller pays for it.
Seller pays for the buyer, buyer pays for a policy for the lender.
Seller pays to buyer and buyer pays to lender. Okay.
For the buyer and for the lender, not to them, but for them.
For them. Okay.
Correct.
And one more question about this 17-point buyer brokerage compensation. And you
Yes.
said the A is the one that seller is willing to pay, and B is the one that we have as a buyer's agent on the BBSA Form 41. And they should be same. Otherwise, if A is higher, let's say 3, and B is 2.5, the buyer keeps a 0.5.
Correct. And then this would
sorry.
be percentage. And then you would check this box, addendum for buyer credit, saying that the seller is going to credit the buyer 0.5% towards closing costs. And that form number is 41C.
41C. So generally, if I were to get a BBSA signed, I would request for 3%. And now in this form, the seller is even not giving the entire 3%. Let's say they are giving 2.5 and I'm okay with the 2.5, but in the BBSA, you said it should be the same number in the B as BBSA.
Correct.
BBSA is 3 and the seller is paying 2.5. I am okay putting 2.5 in B. What do I do?
Well, so here's number one. Number one, you can put 3. The seller might
Okay.
pay it. If they don't,
Oh,
then
okay.
two things can happen. If yours says 3, you have to put 3. You either have to amend your Form 41 with a 41A down to
Okay.
2.5 or ask the seller to pay it. And if the seller says no, then you can still amend your 41 with a 41A and put 2.5. Or if they cross it off and counter, then you want to make sure that you amend your BBSA with 41A to recognize the same number that the seller has countered you with.
Okay, so it's okay to put a high number here. Ask the seller, and in the
Correct.
counter offer, they pay, good. They don't pay, then just change the 41A as a change in the
Correct.
and then okay, got it.
You just, this number here, it has to reflect whatever you agreed with your buyer. Maybe you amended it down to 2.5 before you wrote the offer, then you would write in 2.5. So it just depends on what your BBSA says or your 41A says. It does have to match, unless of course your buyer is going, if your buyer is going to pay, let's say 0.5%, you can always do 2, but again, that's a backwards way of trying to get a credit to the buyer.
Mm.
And it could be that they don't want the credit from the seller and they're willing to pay 0.5 to you and they don't want the 0.5 from the seller gets to keep it. And then they
Oh.
can pay your 0.5% if your BBSA says 2.5.
And it's okay to have 41A done after the counter because
You should do it during the counter. If you're going to make a change, then you should do it during if you get a counter offer back and they changed it to reflect 0.5, then while your buyer's signing this, you should amend your agreement at the same time.
got it. Okay.
Yep.
Thank you.
You're welcome. Any other questions?
Mm.
Well, thank you guys for joining. I'm sorry it was such a small class, but I'm glad you were here. It will be recorded. It'll be put on the hub. So you'll have access to that later on should you have additional questions that I may not be available. But you're always free to call.
So Janine, the other forms,
Mhm.
maybe we go every week a different form like that, is it?
No, I think next time I'm doing listing forms. I never have the same training twice and I never just train on contracts or one type of contract. I train on many things. And then the 4th week of the month, I do what I call the mock offer workshop, and that's live only, where I send a week ahead of time. I send you a property to write an offer on. You write the offer, you bring it in, we go through it together. We talk about, you give me all of you, whoever wrote an offer, which I expect everybody to write an offer. We go through it and we dissect who did what and why.
So next week we are doing listing?
No, next week I have surgery. So next week I'm not going to be here.
Oh,
It'll be
okay.
the week after, the 3rd week.
So how about like there's so many other inspection addendum or financing addendum, so many forms, right? So
Yep.
is there a recording somewhere? Just like this was
Yep.
super.
I have tons of recordings in the hub that go over just inspections, just financing, responses to inspections, responses to financing.
Perfect. Thank you so much. This was like extremely helpful. Thank you so
Yeah,
much.
you're
One
very
question,
welcome.
you talked about the foreign national, right? And that time you say they may or may not be foreign.
This one,
Uh,
FERPTA.
Yeah. So many times a green card holder wants to sell. So what? Is it like a FRIPTA?
Not necessarily. They need to talk to a CPA or an attorney to determine if they are or are not a foreign person. We can't help them with that.
Okay, so it's not okay.
It's not cut and dry
All right.
with the
Thank you
green
so
card.
much. Okay.
You're welcome. Have a
Mm.
great day, guys.
And
Thanks,
have a safe
Janine.
surgery.
Thanks. Bye, guys.